Yeah. I was looking at this public notice. Yes. In fact, could you give me every public notice ID in every newspaper everywhere in the nation for the last 20 years? Yeah. Now, reissuance of temporary order for protection, notice of hearing, Superior Court of Washington, 4 Clown County. Budnick is the petitioner versus Budnick the respondent. Now, when they issued the protection, or the order for protection issued on May 6th, is hereby extended through the new court hearing date on this matter on August 30, 2013 at 2 p.m. at Clallam County Superior Court. May serve responded by mail and publication, and the modified protection order entered on October 16th. Heidi Budnick, petitioner. Yeah. And Paul Chad Budnick as the respondent. Legal number 499647, publication July 24th, so on and so forth. Now, I noticed that when they issued this in public notice in the Sequim Gazette, it named Heidi Budnick as the petitioner, right? And it named myself as a respondent. Now, they would say, well, it's the same on this one, right? She's named as a petitioner. Petitioner Paul Budnick, but I don't see a signature of her on this document. Now, I know that the city of Sequim issued the violation, and they probably could have started the action against me, right? But without the signature of the petitioner. See, here's one of these summons, notice, subpoena that I needed to appear in court, right? It says City of Sequim, yes. Case assigned to Rick Porter, District Court, no contact protection order. Judge, Commissioner, Clerk Keith Wills, and this was for the date of October 11, 2016. Citation number CXZ0145225SQP. That must be Sequim Police, right. The issuance date of 9/27/2016, right. Now, if it says the city of Sequim as the plaintiff versus Paul Budnick, defendant's name, Budnick Paul Chad, how is it possible that on these court documents that the state of Washington should have put the X right there, shouldn't they? Yeah, they should have. So how can the state of Washington prosecute me for a crime when the petitioner didn't sign the form? And how can the state of Washington prosecute me for a crime when there was no service of order? Now, I know the state of Washington, this is the instruction form from the state of Washington. Yes. Law requires the order say if the respondent received notice of hearing and by what method. Now, it seems to me that if the state of Washington doesn't do what the state of Washington's laws require, and then has me arrested as a city, but then decides that they're going to prosecute me as a state. If the state itself didn't follow the state's own instructions, how can the state prosecute me when the state didn't do what the state says they would do? Now, I would say that the state of Washington, and as I understand, the people of the state of Washington are actually trying me, because this was dismissed without cause, and without prejudice. Yes. Now, I can understand that Sequim, Washington issued the violation, even though I wasn't in that city on that day. And this is the actual violation. And they started the prosecution as the city of Sequim. That's correct. Yes, they did. They started it as the city of Sequim. You can see here, yes, you can. But then you, for some reason, the state of Washington got involved and decided that they were going to prosecute. They were going to be the thing. Now, I have emailed numerous oaths of offices in the state of Washington, and now back on the 11th day of October 2016, it was the city of Sequim. Yes. But on the 8th day of March, it was the state of Washington. Yes. So it's kind of like Sequim started, and then they decided, well, the state of Washington's actually the plaintiff in this case, and we're going to charge the man with violating a protection order where he wasn't in that city, and the state themselves didn't follow the laws necessary to issue a protection order. But then, turns out that the city of Sequim decided they were going to be the plaintiff instead of the state of Washington. Now, I have emailed Supreme Court justices in the state of Washington. I've emailed sheriffs in every county that I could find an email address for. I've emailed police departments and fire departments and principals and superintendents. I've emailed elected and appointed oaths of office. I've emailed city employees in King County. I've tried to inform law enforcement of the laws. And when the state of Washington decides to try me for a crime where the state of Washington did not do what their own laws require, it could be that as the person that is going to file for cause actions against every oath of office in the state of Washington, I would say allowing for this protection order to be where it is, still on the books. It's going to cost the people of the state of Washington a lot of money.